President Bola Tinubu has declared a state of emergency in Rivers State. This follows a prolonged political crisis in the state. In a nationwide broadcast, the president, relying on constitutional provisions, announced the suspension of Governor Simi Fubara, his deputy Ngozi Udu, and all the members of the Rivers State House of Assembly for 6 months. The president also nominated retired Vice Admiral Ibokete Ibas as administrator to take charge of the affairs of the state for the first 6 months. Before his broadcast, President Tinubu held an emergency meeting with top security chiefs and National Assembly leaders at the State House. The closed-door meeting, which lasted several hours, ended without any statement or briefing to the press. Joining us now on the show is retired Honorable Justice Professor Mojeed Owoade, Chairman of ActionAid, Nigeria's independent judicial accountability panel. He's been joined also by Andrew Mamedu from our Abuja studio. Mamedu is country director of ActionAid Nigeria and member ActionAid Nigeria's independent judicial accountability panel. In addition, both men will present their findings during their inaugural meeting held in Abuja last week on the analysis of some recent cases of public interest determined by the Supreme Court and the ECOWAS Court capable of informing citizen-led action on judicial accountability. But before we begin, let's take a listen to President Tinubu's declaration of emergency, state of emergency in Rivers State speech. Here is his speech.
Inevitably compelling for me to invoke the provision of the Section 305 of the Constitution of the Federal Republic of Nigeria, 1999, as amended, to declare a state of emergency in Rivers State with effect from today, 18th March, year 2025, and I so do. By this declaration, the governor of Rivers State, Mr. Similaye Fubara, his deputy, Mrs. Ngozi Udu, and all elected members of the House of Assembly State are hereby suspended for an initial period of 6 months. In the meantime, I hereby nominate Vice Admiral Ibokete Ibas, retired, as administrator to take charge of the affairs of the state and the interests of the good people of Rivers State.
Well, we now have with us this morning Milord. Thank you very much for joining us. Mr. Mamedu, thank you very much for joining us. Well, Milord, let me start with you. Yes. Now, your panel, an 11-man panel that you led to review some of these recent public interest issues, arrived with specific reference to Rivers State. Okay. That, in fact, the Supreme Court would seem to have created this problem, in part, because the Supreme Court looked into the issue of defection, which was not even a direct issue, that was before it. So, and, your body was talking about accountability. I would like you to talk about, the accountability of the Supreme Court, their lordships, in this particular matter. And after Milord has spoken, Mr. Mamedu, I would like to come to you for us to give us a comprehensive view, because there were 3 cases that the Owoade-led panel looked into, to just give us some of the key recommendations and observations, in the cases involving Rivers, the ECOWAS Court, and the other case involving APC and Rivers State Independent Electoral Commission. Milord.
Thank you very much. We reviewed 3 cases of public interest in the panel. One of them is the Rivers State Assembly matter. You will recall that the initial suit was before the Federal High Court, Abuja. That, if I remember, that was suit number 1163. And the question that arose was, okay, since the Assembly has only 4 members, will it be right that the federal government continues to give allocation through the central bank to Rivers State on the ground that the assembly as constituted was not proper. The Federal High Court held the view, one, that it has jurisdiction, and two, that, well, a four-man assembly cannot work, that therefore came to the conclusion that the federal government should stop appropriation to rivers on the ground that there was no valid appropriation bill to maintain such practices. This matter went to the Court of Appeal. The Court of Appeal held first that, yes, in this matter, the Federal High Court has jurisdiction. That's equally right. And that the Rivers State government cannot now talk about a doctrine of necessity to uphold the idea to maintain their allocation on the ground that you recall that there was a previous matter before the State High Court on the legality of defection. That came to another panel of the Court of Appeal. And they said, no. State High Court, you don't have jurisdiction. Go back. So at the appropriation bill matter, the Court of Appeal too held the view that, well, since nothing has been done about your case, one panel of the Court of Appeal struck out the suit area. The situation, let's maintain the status quo. Your people are still in existence, so you don't need any doctrine of necessity. It was this same matter that now got to the Supreme Court as Appeal 1174, Cross Appeal 1174B, and other matters connected with it. Okay? Virtually, if you read the lead judgment of Agim, GSC, he agreed with the Court of Appeal that let's make issue about doctrine of necessity. You have not done anything about the case that was struck out. Maybe it's in another federal high court or whatever. Therefore, your assembly membership stands. You don't need necessity. Let it work that way. Okay? But the lead judgment formulated only one issue in the case, which was the issue of jurisdiction. In fact, the court says that in all these consolidated appeals, the only issue to be determined is the issue of whether Federal High Court has jurisdiction or not. Fine. And of course, they held in agreement with the Federal High Court and the Court of Appeal that the court has jurisdiction. If you stop at the lead judgment, you will think there is no conformity between the orders that was eventually made, which was very wide, go back, all this, with the idea of simply deciding appropriation bill. And we felt at one stage, when we got seized of the lead judgment, that you have left something, something is still at stake. What about the legality? Existence is different from legality. Well, have they defected or not? That is what you think with the lead judgment. But now part of the judgment of the Supreme Court was the contributory judgment of Justice Iwonsu GSC, who actually, without being asked so to do, without formulating any issue on defection, so to say, decided what the public has been waiting for on the issue of the legality of the defection.
But can't the Supreme Court take an activist role, even when an issue is not before it, as we have seen in previous cases, then decide to be an activist court of law?
No.
But I've asked that, just to link the point about what President Tinubu did yesterday.
Yeah.
I've argued this morning that what President Tinubu did is an assault on the Constitution of Nigeria. What do you think? And also about judicial activism, whether it applies in the matter that your panel
Your first question first. I don't think it is right for any court to breach the position of the law. That judgment, that contributory judgment was not asked for. Of course, lawyers will say it's obiter. The question is that it has a larger issue, a problem of whether it has a binding effect. That's a very, very serious thing. Because in fact, for media, if you look at the media, you find out that some people are still contesting the legality in one other federal high court, I think Labour Party. as if the Supreme Court said nothing. That is the type of problem that will be created by that contributory judgment. Perhaps if they are stopped at the lead judgment and the others agreed, it will have been a different thing. But the question of determining the legality, whether they have done it rightly, or now they say, yes, they were just boasting. They never defected. That was legality. It was not right.
Tinubu dancing on the grave of the Constitution.
That is totally a different matter. If we talk about what it is, the law, as proposition of an is proposition, we'll be able to say the law is dicey, because I listened to you earlier. The law is dicey. Nobody seems to know the limit of 305, Section 305, except it is properly interpreted. But clearly, it gives a lot of power for the National Assembly as check and balance to moderate, to modify, or do anything about such. I think the reliance of the Constitution for 305 is on the National Assembly. You can do anything you want with it. You may even reject it, you may modify it, because they talk about the details. That details is not really known. You referred earlier on to Section 188. Yes, Section 188 talks about how a governor can be removed, impeachment, sickness, etc. No one is sure that that precludes removal in a state of emergency. Like I said, that is for interpretation. But following the common trends, if we talk about an ought proposition, what is it that is ought to be? All the parties concerned are obliged to follow democratic principles, either in terms of interpretation or in terms of actions, because the Constitution expects that we'll be ruled and governed, having regards to democratic principles. Thank you very much.
Well, Mr. Mamedu, let's come to you quickly. A quick summary of the findings of the Justice Owoade-led panel, 11-man panel, on issues of accountability in the 3 cases that panel looked at.
Okay, thank you very much, Ruben. Good morning. Just to say that, first of all, when we talk about accountability, accountability is a major bane of our democracy. If you look at the principal-agent relationship, where you have the citizens as the principal and the government as the agent, the principal mandates the agent to take some certain steps, responsibility on its behalf. And having that in place, there are expectations that the agents are supposed to uphold, including what to do and what not to do. And if there are discrepancies, there are other institutions, when there are challenges, there are other institutions that can come in and mediate. That's where the judiciary comes to play. And that is why, for us, the judicial accountability is key, it's sacred. It's supposed to be independent. That's why it's independent. And that's where also the National Assembly is supposed to also come to play. They are supposed to play that check and balance to hold the executive accountable. So it's, and over the years, we have seen series of judgments. And recently you hear people talking about controversial judgments up to the Supreme Court level. Even recently we had the Plateau State judgment, the Imo State judgment. So all of those, the Plateau State judgment, of course, the judgment from the Supreme Court showed that the appeal court's ruling was not the right one, and that brought some level of controversy. So what we then did as ActionAid, how do we ensure that the level of accountability, citizens' involvement, and ownership of this process is promoted? So that was why we brought this team together. Of course, team of eminent, qualified, retired justices of Nigeria. We also had professors of political science, media experts, development experts, even lawyers in this team, looking at all of these issues. On the basis of that, we then say, let's pick some judgments that are of interest to to the country. And we picked 3 of them. 2 were, interestingly, were around River State, the one that Milord has just spoken about, and the second one was around the local government judgment of River State. Then the third one was the ECOWAS judgment. So it's not just limited to the judgments from Nigeria. And for the ECOWAS judgment, which I will start from, it was basically around NSAS that says that the government erred in not respecting the rights of Nigerians to peaceful protest. So we have seen that degenerate over the years. We have gotten to a point where citizens are now told you cannot protest in public. You have to go to a stadium, an enclosed place for you to be able to do your protest. We have seen actions of the police, of the military being deployed, even the DSS also being involved in trying to stop citizens from protesting. So the ECOWAS judgment was quite clear. And secondly, ECOWAS judgment also said you need to pay some monies, some penalties, fees to some certain persons, those that were added to the judgment. But 9 months after, that has still not happened. So our recommendation was, of course, the federal government needs to obey the ECOWAS judgment. It's binding on Nigeria, so because we are signatory to that. So if we are signatory to it, that judgment is binding to us as a country, and we must respect it. Then we also looked at how do we ensure that involvement of police or other organs, security agencies, is left at the barest minimum or not allowed at all, except when necessary. But who define the necessity? How do you manage that? So we also looked at that. How do we make sure that the citizens are not, protests and all of that are not criminalized? And the ECOWAS judgment was clear around that. Then the issue of the other judgments, if you looked at the judgments that Milord just talked about, the judgments are not easy to read. So one of the function of this panel is to try and break down judgment for Nigerians to understand. People look at this judgment and they look very complicated, and you are reading the judgments and you are looking at several documents, but how do you make it simple enough? How do you make it short enough? How do you make it concise enough for citizens to read, understand it, and there are no contradictory issues within them, and if there are, it's our responsibility as a panel to point them out. So these are some of the recommendations that we came about. Of course, the judgment, we recognize all the good things, all the right things that were said in the judgment. We recognize all the positives that were done by the judgment, but the gaps that existed, we recognize them and we said, these are the recommendations. Ultimately, the citizens are supposed to hold both the executive and the judiciary accountable, and the legislative accountable, 3 arms of government accountable. They are all there as agents of the citizens, which is the principle here. Thank you.
Thank you so much. I know that, that we're still going to dissect a lot of things. It's just that because of our time, we're trying to get in as many things in as much as possible. Honorable Justice, I just wanted to ask you, going back to the River State matter, because that's definitely on the minds of a lot of people, and a lot of, like I said earlier, legal minds. The NBA has released a statement with regards to this appointment of a sole administrator for the state. The remit of his power in terms of regulations or that would be passed on to the Federal Executive Council. What is the legality of that in terms of, in accordance to the Constitution, the law, can he, in this position, make regulations or law that's subject to the FEC, or should it be the responsibility of the National Assembly in this case?
Do not forget, when we refer to the speech of the head of state, he said he shall not make laws. The question which I think you have raised earlier while I was watching is whether the president said he can make regulations.
Yes.
The question is whether those regulations will be subject to the Federal Executive Council, which Dr. Abati said, of course, does not have power of lawmaking. You can equally say that regulation is not law. But more important is what I've said earlier. National Assembly has a fundamental role, a big role, because 305 just talk about details. That details it's the National Assembly that needs to moderate it. And maybe we should just wait and see.
Well, they say they're sitting today, so let's see
We should
what the
just wait
outcome
and
of
see.
that will be.
We should just wait
Okay,
and see.
so Mamedu, I'll come to you on this. And thank you, and thanks to ActionAid for you guys doing this, putting your money in it, because I know it didn't come cheap. It cost a lot, putting your time and effort into it. Is there any way well-meaning Nigerians can continue to support ActionAid to be able to bring more, cases up like this? Because I know you have to have, you probably had a secretariat. You have to run it. This thing costs money. It's not cheap. To be able to get the likes of my dear retired justice, on the seat and everybody there, it's not cheap. How can Nigerians support ActionAid? Because this is a good venture. God bless ActionAid. This is a path to having sensible democracy in this country, not a demonstration of grace. So that's the first question. How can we support ActionAid to continue? And what other cases are you guys looking at? Are you going to look at the Imo case, for instance? Supreme Court judgment where third became first? Because that's another one we would like to look at and get opinions, about it. For you, sir, now that it has shown that the Supreme Court has become activist in nature, because that same case, like in the obituary you talked about, that the Supreme Court decided to take on by themselves, is still a case pending in the Federal High Court.
That was exactly what I said.
That's just recently, judgment has been reserved in that case.
Exactly.
But the Supreme Court have made finality over it.
Exactly.
So, what they say is this. You can go about the fallibility talk. It's not that because it's not fine because it's fallible. It's not fine. The truth is, with all of this recommendation, will the NJC now sit and look at these things again? Because that's why you are doing all of this. There needs to be accountability. With that same judgment of one activist in there, we have plunged the state into a state of emergency today. So cost judgments do matter. What's your take on that, sir? Let me come to Mamedu first and come to you afterwards. Mamedu, please. How can we all support ActionAid?
Okay, thank you very much. Just to say that the group of Nigerians we are working with, to be fair, and they are just volunteering. Over the years, if you listen to valedictory sessions of some justices of the appeal court or the Supreme Court, some of them express their frustration on the system, what can happen, how they can change it and all that. Now, this is a little thing we are doing. And the truth is, all the justices, all the people that we have brought in, we can't say we are paying them, we can't pay them. So what we pay is just their cost of them to attend. We fly them in, we get their accommodation, we pay all of those costs. So but we are doing this in partnership with the Ford Foundation. And of course, we are looking at expanding it. So the next session, let me give you a practical instance. We intend to build this and make it big. We are going to make it a live program. We get our rise to air it, where the debates, it's a robust session. We had like a 4-day session debating all of these things. And you have justices there. We're going to expand the panel to have more retired justices, even from the Supreme Court, in it, that, of course, will look at these issues and bring up the gap. This, for us, one thing it will do is it will make the judiciary know that people are watching, and will make them a bit more conscious of what judgments they are passing out. That is on one hand. So, of course, for people to come and support ActionAid, we have various platforms in our website on how you can support ActionAid for us to expand it. We need to make it live events. We need to get Nigerians in that room where those debates are happening. We need to get more lawyers in that room. We need to expand all of those. So we can do that. But in a twin action for us in ActionAid, beyond just the IJAP, we have another group called the Movement for the Transformation of Nigeria. It's again about accountability. So how do we ensure that there's accountability within the system? So Motion is working with over 100 organized groups, from market women to NBA to the journalists, Farmers Association, all of those. So all of this group, and some, of course, some affiliate of NLC and all of that. And some of this group, over 100, we have currently about 30 million of those. And what we are doing is, how do we build citizens' consciousness to hold the government accountable? Our major responsibility as ActionAid is two major things. One is, how do we deal with issues of poverty? And two, how do we deal with issues of injustice or social justice, as we may call it? So if we're dealing with those two things, accountability is central, holding the government accountable. The Constitution is quite clear on the role of the citizens in doing that. So motion, 30 million persons in days to come, weeks to come, we're going to see more people holding and asking questions. If you come to the River State judgment, basically, so a couple of questions. Why is it that if we have to declare a state of emergency and put a sole administrator, why do we always go back to get a retired military person to be the head of the sole administrator? Is that our military mentality or the military hangover that we still have? Are they better managers? If I'm not conceding that River State needed to have a sole administrator, and in this situation, you don't actually need fire for fire. You need to look at peace. So you look at somebody that has a background on security and peace building. So it's not about warfare. It's not about, so if you go for it with warfare, recently we got to a point where our oil production dropped to as much as 400,000 barrels per day. And if we get to that, that is where the poor people would suffer the most. So those living in poverty, which is our constituency as ActionAid, which we take side from, they are the ones that will suffer the most, and we need to ensure that we don't get to that level.
Thank you so much, Mamedu.
The National Judicial Council is a quasi-judicial body. It does not raise, for that reason in particular, it does not raise complaints or petitions on its own. But at another level, in ActionAid, we have been able to say that, and we told the Parliament, we gave these papers to the National Assembly, that the NJC should be more proactive, should be proactive in its affairs. In other words, not only to discipline when there are complaints, but also to monitor conflicting judgments, monitor inconsistencies in judgments, so that they are in an advisory capacity, they may reform, as it were, the judicial system. I think.
Okay. Well, thank you. Just before you go, what will you advise the parties involved to do? For example, there's still an option to go to court for interested parties in River State. Is there not an option? 2, the National Assembly that will take the proclamation from the president. What will you advise the National Assembly to do? Particularly as his powers under Section 11, which seem to have been taken away from it. What will you advise the National Assembly and the River State persons involved in the face of this
difficult question
violation?
As for the National Assembly, they should listen to the public, because the power is actually with them now. They can do and undo. If they feel that it is not right to appoint an administrator, or it hasn't gotten to that stage, they may reject it. And that ends the matter. That ends the matter. It's more difficult to advise the parties in the River State Assembly and all that. But let us go back to what the IJAP has said, that in all these matters, in fact, we appealed that politicians and stakeholders should learn to settle themselves. If it wouldn't have gotten to that stage, it can still be done by some compromises. It can be done by some settlements rather than this stage. Thank you.
It can still be done by, as the president advised, Fubara stooping to conquer, which was the advice of the president. Thank you very much, my Lord.
I'm grateful.
Retired Justice Owoade, for joining us. And thank you, Mr. Andrew Mamedu.